So can you move assets during a lawsuit? Supreme Court Justice Antonin Scalia answers the question this way, and I quote, "A creditor has no cognizable interest in the assets of a debtor prior to obtaining a judgment. Anyone can transfer their assets all day long until the sheriff shows up with a writ of execution pursuant to a court order." So if you've been sued, worried about a lawsuit, divorce, or similar concern, we'll talk about what will happen if you move your assets during a lawsuit and if you should or shouldn't do it. Moving assets during a lawsuit is often called fraudulent transfer, fraudulent conveyance, and now called a voidable transaction. And it's when somebody transfers or converts a non-exempt asset, such as cash, stock, or real estate, with the intent to delay or hinder collection by a creditor. Hi, I'm the business guy. I'm the CEO of Asset Protection Planners and Lawyers Limited, which started in 1906. We have attorneys on staff and are the nation's largest asset protection company. And today we're talking about moving assets during a lawsuit. And if you're watching this video on YouTube, please click the like button below so YouTube promotes it. Thanks so much. And if you haven't already, you can click the subscribe button below so that when more videos come out like this one, you'll be up to date right away. Now, the important thing to know is that fraudulent conveyance is a civil remedy only. It is by and large not a crime. And as the largest asset protection company in the nation, I have never seen anybody going to jail for transferring assets during a lawsuit. The creditor's only remedy, and this has been established by many appellate decisions, is to undo or reverse the fraudulent transfer, which means that the debtor is in the same position he was before he made the transfer. I've been in the asset protection business for 31 years. We have, I believe, over 80,000 clients in our database and have done tens of thousands of corporate and trust filings. And whereas a handful of states have added this to their criminal code, it typically deals with a very specific intent. Because of fraudulent transfer laws, many domestic or U.S.-based asset protection trusts do not tend to work very well if you move your assets into one of those during a lawsuit because a judge can easily undo the transfer. Whereas an offshore trust is outside of the local court's jurisdiction, and your local courts do not have the right to issue court orders to our foreign trustee/law firm. So the term fraudulent conveyance sounds scarier than it really is. It is simply a civil matter, not typically a criminal one. So in my experience, it's usually better to do it and then make them fight for it than it is to just roll over like a dead dog and leave your assets out in the open. Put up a fight. Make them work harder to take your assets than you had to work to earn them in the first place. Now, this isn't legal advice. Talk to an attorney for that. We have attorneys on staff who you can talk to, so visit our website and fill out a free consultation form for that. Fraudulent transfer laws are statutory, meaning they're written in the law books, and our local fraudulent transfer laws do not provide for criminal remedies for moving assets during a lawsuit. And they do not give the ability to assess additional damages or fees against the debtor. Now, there are certain drawbacks to attempting fraudulent conveyance that involve friends or family members. If you move your assets during a lawsuit to them, these people will often end up in a fraudulent transfer lawsuit. So what a person ends up doing is dragging loved ones into their problems. That is, people who tried to help you by receiving your assets get stuck with huge legal bills. And that will not be a happy conversation on Thanksgiving Day. So don't transfer assets to friends or loved ones. Don't transfer to your spouse. Dragging your wife into a lawsuit does not boost the romance. We also get questions from attorneys and accountants as to whether they can get held liable for assisting a client in making a fraudulent conveyance. The answer here is typically no. For example, the Florida Supreme Court dealt with this issue specifically in a dispute between a debtor and a bank. The court held there is no liability for a third party, such as an attorney, accountant, or financial advisor, in assisting or conspiring with a debtor to make a fraudulent conveyance. In California, however, there may be discipline for attorneys who assist clients in moving assets during a lawsuit. And that is why we have so many attorneys around the country referring their clients to us, since we don't have those concerns. However, for attorneys, be careful that you only give legal advice, because if you become a party to moving assets during a lawsuit, you may have civil or ethical liability. For example, don't put the conveyance from your client into your trust account, knowing that this client has the intent to avoid a creditor. If you have assets you want to protect and you're not sure what to do with them, but you see that giving them to somebody else isn't a good idea, give us a call at 1-954-400-1050 or visit assetprotectionplanners.com to speak with one of our attorneys or consultants. Please click like, subscribe, and share this video with others. Thanks for watching. See you next time. This is The Business Guy.